President, distinguished colleagues, I am Issa Jibrin, representing the very good people of Kogi East. Mr. President, my highly respected colleagues, please permit me to lead debate on this very important bill seeking to repeal the Violence Against Persons Prohibition Act 2015 and enact an act to eliminate violence in private and public life, prohibit all forms of violence against persons, and to provide maximum protection and effective remedies for victims and punishment of offenders and for related matters. This bill was read for the first time on Tuesday, 1st February 2022. Mr. President, distinguished colleagues, due to the far-reaching nature of this bill, let me crave your indulgence to extensively highlight the background, which I believe will not only provide a proper context for this legislative initiative, but also motivate the National Assembly to accelerate the legislative process in enacting this bill. Background. This act was enacted in 2015 against a backdrop of the rising cases of violence, especially domestic violence against women. The initial bill sought protection for women from male domination violence. In the face of opposition to its obvious gender-biased nature, the promoters renamed it, tinkered with some of its provisions, introduced seemingly gender-neutral language, and successfully obtained its passage. Its explanatory memorandum states that it prohibits all forms of violence against persons in private and public life and provides protection and remedies for victims and punishment of offenders. Upon close scrutiny of the Act, it becomes obvious that it contains prohibitions that are inimical to the realization of its objectives. Mr. President, distinguished colleagues, going through the provisions of the Act, it is obvious that it is plagued by substantial and drafting challenges. This underscores the necessity for a holistic reform of the Act to bring the provisions in line with the realities of societal change and drafting standards to effective dispensation of justice. Some of the major areas of concern in the Act are highlighted below. There are several strict liability offenses in the Act. These are instances where mental element is not needed. There are instances where mental element is not needed, but only the physical element, which is all required to complete the offense. This therefore calls for a review to introduce elements of intention. The punishments of fine and imprisonment in the Act have become infinitesimal to have meaningful deterrent effect. This is particularly so in view of the current economic realities in Nigeria. In Section 1 of the Act, the offense of rape needs particular attention. There is a need to make a distinction between absence of consent and consent obtained by fraud, undue influence, and other unlawful means. The Act contains inadequate provisions for compensation of the victims of violence. The penal focus is on fines and imprisonment, with little on compensation. In addition to the punishments, it is better by way of reparation for victims to make adequate provisions relating to compensation. The grievous nature of certain offenses in the Act, especially Section 22(1), makes the punishment provided inadequate. In view of the rampant cases of chemical attacks, such as acids and other substances, offenders under this section should not be given an option of fine. Similarly, the term of imprisonment needs an upward review. Section 27 of the Act, which vests jurisdiction in the High Court of the Federal Capital Territory, creates crisis of interpretation. Under the provision, the High Court of the Federal Capital Territory needs to be empowered by an Act of Parliament to exercise jurisdiction. This is certainly not the legislative intent therein. Consequently, the component requiring empowerment by an Act of Parliament is unnecessary. There are instances of derogatory expressions in the Act. An example is mentally retarded, used in Section 28(4). This needs to be replaced with a subtle legislative language. There are many cases of wrong cross-referencing in the Act. The implication is that the operators of the Act run into difficulties when it comes to implementation. This opens a floodgate of litigation which can be avoided by legislative option. The use of the term shall and may in some sections of the Act do not convey legislative intent. Those terms are used haphazardly without due consideration of their outcomes. For example, in Section 33(1), it is provided that whenever a court issues a protection order, the court shall make an order, A, authorizing the issue of a warrant for the arrest of the respondent in the prescribed form, and B, suspending the execution of such warrant subject to compliance with any provision, condition, obligation, or order imposed under Section 331 of this Act. The implication of the use of shall is a mandatory effect, which could not have been the legislative intent. The word may is more appropriate in the circumstance. In Section 34, a strange commissioner is introduced for the purpose of making an application for variation or setting aside of a protection order. This reduces the provision with confusion, as commissioner does not appear anywhere before and after this section. Besides, commissioner is not defined in the interpretation section. The Act makes reference to legislations that are already repealed. An example is Section 40, which makes reference to the Companies and Allied Matters Act 1990. The current law is Companies and Allied Matters Act 2020. Conclusion. Mr. President, my highly distinguished colleagues, this Act is notable for its innovation towards addressing violence in all ramifications. However, the several challenges and inadequacies inherent in it call for urgent action to reposition the legislation for efficiency. A major innovation in this bill is the creation of Victim Support Fund to cater for victims of violence and further provide for composition, funding, and management of the fund. Mr. President, distinguished colleagues, it is because almost all sections of the Act are affected that the bill seeks to repeal and reenact the legislation to avoid making the legislative proposal clumsy. I therefore call on you to give full support to this bill in order to achieve the laudable objectives of the legislation. I thank you very much, Mr. President.
Distinguished Senator, a bill for an act to repeal the Violence Against Persons Prohibition Act 2015 and enact the Violence Against Persons Prohibition Bill 2022 to eliminate violence in private and public life, prohibit all forms of violence against persons, and provide maximum protection and effective remedies for victims and punishment of offenders, and for related matters 2022 second reading taken, and the bill is referred to the Senate Committee on Judiciary, Human Rights and Legal Matters for further legislative action to report back within 4 weeks. Leader of the Senate.
Mr. President,